into an abyss of injustice, where they experience the bleakness of corroding despair. I hope, sirs, that you can understand our legitimate and unavoidable impatience. You express a great deal of anxiety over our willingness to break laws. This is certainly a legitimate concern, since we so diligently urge people to obey the Supreme Court's decision of 1954 outlawing segregation in the public schools. It is rather strange and paradoxical to find us consciously breaking laws. Obey the Supreme Court decision. Okay. One may well ask, how can you advocate breaking some laws and obeying others? Okay, so this is what we're looking for. The answer is found in the fact that there are two types of laws. There are just laws and there are unjust laws. I would agree with St. Augustine that an unjust law is no law at all. Wait. I don't know all of the legislative rulings and everything. Okay, 54. For Brown v. Board, was this, I don't know the answer to this. When Brown v. Board ruled for desegregation, did this apply broadly to it applied broadly to everything, not just schools, right? It was just public schools? Was it just public schools? So so after Brown v. Board happens, is it still legal to segregate, read the case? Oh boy. Brown v. Board of Education. Brown v. Board of Education. Supreme Court.pdf. Is it this? These decisions were so short. It's 14 pages compared to it's so crazy how short this opinion is. Fuck it. Brown v. Board of Education. This is the syllabus, meaning that this part wasn't written by any of the justices. Is this 14 pages only the syllabus? Counsel for Parties, opinion of the court. No, it's not. Okay, so it's just very, very shortly written. Okay. Segregation of white and Negro children in the public schools of a state solely on the basis of race, pursuant to state laws permitting or requiring such segregation, denies to Negro children the equal protection of the laws guaranteed by the 14th Amendment, even though the physical facilities and other tangible factors of white and Negro schools may be equal. The history of the 14th Amendment is inconclusive as to its intended effect on public education. The question presented in these cases must be determined not on the basis of conditions existing when the 14th Amendment was adopted, but in the light of the full development of public education and its present place in American life throughout the nation. ABC, this is C. Where a state is undertaken to provide an opportunity for an education in its public schools, such an opportunity is a right which must be made available to all on equal terms. D. Segregation of children in public schools solely on the basis of race deprives children of the minority group of equal educational opportunities, even though the physical facilities and other tangible factors may be equal. And E. The separate but equal doctrine adopted in Plessy v. Ferguson has no place in the field of public education. There's an asterisk, a footnote on one of these up here that we read. Together with number 2, Briggs et al. Another case, an appeal from the U.S. District Court for the Eastern District of South Carolina, argued law, an appeal from the U.S. Okay, it's just whatever. Oh, it's up here for the court. Okay. And F, the cases are restored to the docket for further argument on specified questions relating to the forms of the decrees. Counsel for Parties. Interesting. Is that part of the... Oh, it's just arguing, or it's just presenting the arguments that the, I guess it'd be the plaintiffs we're bringing forward. Robert L. Carter argued the cause for appellants in number 1 on the original argument and on the re-argument. Thurgood Marshall argued the cause for appellants on number 2 on the original argument, and Spotswood W. Robinson III for appellants in number 4 on the original argument, and both argued the causes for appellants in numbers 2 and 4 on the re-argument. Lewis L. Redding and Jack Greenberg argued this cause for respondents in number 10 on the original. Oh, okay. Okay. So is this et al. These are all the people arguing, I think, all these different cases. Yes. Okay. This has been consolidated. All of these cases, I think, have all been consolidated from all these other cases into one case at the Supreme Court. Was overhearing. Okay. Or it was providing an opinion on, I guess. Okay. On the briefs for Robert L. Carter, blah, blah, blah. Okay, we don't need to read their names. Don't care about this. Okay, argued this. Okay. This is just, literally counsel for the parties. Okay, so it's just saying who argued and what. Okay. Mr. Chief Justice Warren delivered the opinion of the court. These cases come to us from the states of Kansas, South Carolina, Virginia, and Delaware. They are premised on different facts and different local conditions, but a common legal question justifies their consideration together in this consolidated opinion. In the Kansas case, the plaintiffs are Negro children of elementary school age residing in Topeka. They brought this action in the United States District Court for the District of Kansas to enjoin enforcement of the Kansas statute, which permits but does not require cities of more than 50,000 population to maintain separate school facilities for Negro and white children. Pursuant to that authority, the Topeka Board of Education elected to establish segregated elementary schools. Other public schools in the community, however, are operated on a non-segregated basis. The three-judge district court convened under 28 U.S.C. found that segregation of public schools had a detrimental effect on Negro children, but denied relief on the ground that Negro and white schools were substantially equal with respect to buildings for safety. Okay. The South Carolina case, Briggs v. Elliott, the plaintiffs are Negro children of both elementary and high school age residing in Clarendon County. They brought the action to enjoin we're inferior to white schools, but courts sustain the validity of the contest. Okay. And then in the Virginia case, denied the request for relief. The court's found, I don't know. And then in the Delaware case, okay, they brought this action. Okay. Self-result in fair education. Okay. All right, hold on. Just as a real quick thing, for all of these court cases that were consolidated into a single case, this is just an important fact for you to know, just because I see, especially today, especially with this comment, is all the weird Nazi revisionism and all the weird historical revisionism that happens in conservative communities. Part of the reason why this was brought before this court, and I believe part of the consideration of the judges, I haven't read this full opinion though, so we'll see if my reading of the opinion was correct. Part of the argumentation is that it's not just that separate but equal wasn't good, it's that separate but equal was a myth. It wasn't that we had separate educational institutions in the United States, and then because they were segregated by race, they were no good. It was because we had separate educational institutions, and even if they were found to sometimes have parity with some features, the educational opportunities were not equal among those two things. This was part of the consideration, and that's what, on the footnotes, that's what they're going over in all these cases, that this is part of the consideration in all these cases that eventually rose up at the Supreme Court. Okay. In each of these cases, minors of the Negro race, through their legal representatives, seek the aid of the courts in obtaining admission to the public schools of their community on a non-segregated basis. In each instance, they had been denied admission to schools attended by white children under laws requiring or permitting segregation according to race. This segregation was alleged to deprive the plaintiffs of the equal protection of the laws under the 14th Amendment. In each of the cases, other than the Delaware case, a three-judge federal district court denied relief to the plaintiffs on the so-called separate but equal doctrine announced by this court in Plessy v. Ferguson. Under that doctrine, equality of treatment is accorded when the races are provided substantially equal facilities, even though these facilities be separate. In the Delaware case, the Supreme Court of Delaware adhered to that doctrine, but ordered that the plaintiffs be admitted to the white schools because of their superiority to the Negro schools. The plaintiffs contend that segregated public schools are not equal and cannot be made equal, and that hence they are deprived of the equal protection of the laws. Because of the obvious importance of the question presented, the court took jurisdiction. Argument was heard in the 1952 term, and re-argument was heard this term on certain questions propounded by the court. Re-argument was largely devoted to the circumstances surrounding the adoption of the 14th Amendment in 1868. It covered exhaustively consideration of the amendment in Congress, ratification by the states, then existing practices in racial segregation, and the views of proponents and opponents of the amendment. This discussion and our own investigation convince us that, although these sources cast some light, it is not enough to resolve the problem with which we are faced. At best, they are inconclusive. The most avid proponents of the post-war amendments undoubtedly intended them to remove all legal distinctions among all persons born or naturalized in the United States. Their opponents, just as certainly, were antagonistic to both the letter and the spirit of the amendments, and wished them to have the most limited effect. What others in Congress and the state legislatures had in mind cannot be determined with any degree of certainty. An additional reason for the inconclusive nature of the amendment's history with respect to segregated schools is the status of public education at that time. For a general study of the development of public education prior to the amendment, see Butts and Kremen, History and Education, blah, blah, blah. School practices current at the time of the adoption of the 14th Amendment are described in blah, blah, blah. Although the demand for free public schools followed substantially the same pattern in both the North and the South, the development of the South did not begin to gain momentum until about 1850, some 20 years after that the North. The reasons for the somewhat slower development in the South, for example, the rural character of the South and the different regional attitudes towards state assistance, are well explained in Cubberley. In the country as a whole, but particularly in the South, the war virtually stopped all progress in public education. The low status of Negro education in all sections of the country, both before and immediately after the war, is described in this. Compulsory school attendance laws were not generally adopted until after the ratification of the 14th Amendment. It was not until 1918 that such laws were enforced in all the states. Okay. In the South, the movement towards free, common schools, supported by general taxation, had not yet taken hold. Education of white children was largely in the hands of private groups. Education of Negroes was almost non-existent, and practically all of the race were illiterate. In fact, any education of Negroes was forbidden by law in some states. Today, in contrast, many Negroes have achieved outstanding success in the arts and sciences, as well as in the business and professional world. It is true that public school education at the time of the amendment had advanced further in the North, but the effect of the amendment on northern states was generally ignored in the congressional debates. Even in the North, the conditions of public education did not approximate those existing today. The curriculum was usually rudimentary. Ungraded schools were common in rural areas. The school term was but 3 months a year in many states, and compulsory school attendance was virtually unknown. As a consequence, it is not surprising that there should be so little in the history of the 14th Amendment relating to its intended effect on public education. The first cases in this court construing the 14th Amendment, decided shortly after its adoption, the court interpreted it as proscribing all state-imposed discriminations against the Negro race. As proscribing all state-imposed discriminations. Proscribing, does that mean getting rid of? Prescribing means like recommending, and proscribing means recommending against? Forbid, yes, okay, proscribing. Why don't we use that word anymore? Do you prescribe something or do you proscribe something? Was Negro the common word to refer to black people at the time? Was the writer purposely using the word to emphasize a point? No, this is what they called themselves. Sorry. It was just like the word. Same thing with like colored people. I think like it could have a negative connotation because people were racist, but I don't think it was seen as like if you're using that word, you're being intentionally like fucked by doing it. Why don't you pronounce it Negro? Is it Negro or Negro? Negro. I don't know. Where were we? The doctrine, separate but equal, did not make its appearance in this court until 1896 in the case of Plessy v. Ferguson, involving not education but transportation. American courts have since, footnote 6, the doctrine apparently originates in Roberts v. City of Boston, upholding school segregation against attack as being violative of a state constitutional guarantee of equality. Segregation in Boston schools was eliminated in 1855, but elsewhere in the North, segregation of public education has persisted in some communities until recent years. It is apparent that such segregation has long been a nationwide problem, not merely one of sectional concern. Wait, where was I? American courts have since labored with the doctrine for over half a century. In this court, there have been 6 cases involving the separate but equal doctrine in the field of public education. In Cumming v. County Board of Education and Gong Lam v. Rice, the validity of the doctrine itself was not challenged. In the Cumming case, Negro taxpayers sought an injunction requiring the defendant school board to discontinue the operation of a high school for white children until the board resumed operation of a high school for Negro children. Similarly, in the Gong Lam case, the plaintiff, a child of Chinese descent, contended only that state authorities had misapplied the doctrine by classifying him with Negro children and requiring him to attend a Negro school. In more recent cases, all on the graduate school level, inequality was found in that specific benefits enjoyed by white students were denied by Negro students of the same educational qualifications. In none of these cases was it necessary to re-examine the doctrine to grant relief to the Negro plaintiff. In another case, the court expressly reserved decision on the question whether Plessy v. Ferguson should be held inapplicable to public education. In the instant cases, that question is directly presented. Here, unlike Sweet v. Painter, there are findings below that the Negro and white schools involved have been equalized or are being equalized with respect to buildings, curricula, qualifications, and salaries of teachers, and other tangible factors. In the Kansas case, the court below found substantial equality as to all such factors. In the South Carolina case, the court below found that the defendants were proceeding promptly and in good faith to comply with the court's decree. In the Virginia case, the court below noted that the equalization program was already afoot and progressing. Since then, we have been advised in the Virginia Attorney General's brief on re-argument that the program has now been completed. In the Delaware case, the court below similarly noted that the state's equalization program is well underway. Okay. Our decision, therefore, cannot turn on merely a comparison of these tangible factors in the Negro and white schools involved in each of the cases. We must look instead to the effect of segregation itself on public education. In approaching this problem, we cannot turn the clock back to 1868 when the amendment was adopted, or even to 1896 when Plessy v. Ferguson was written. We must consider public education in the light of its full development and its present place in American life throughout the nation. Only in this way can it be determined if the segregation of public schools deprives these plaintiffs of the equal protection of the laws. Today, education is perhaps the most important function of state and local governments. Compulsory school attendance laws and the great expenditures for education both demonstrate our recognition of the importance of education to our democratic society. It is required in the performance of our most basic public responsibilities, even service in the armed forces. It is the very foundation of good citizenship. Today, it is a principal instrument in awakening the child to cultural values, in preparing him for later professional training, and in helping him to adjust normally to his environment. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state is undertaken to provide it, is a right which must be made available to all on equal terms. We come then to the question presented. Does segregation of children in public schools solely on the basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunities? We believe that it does. And Sweet v. Painter, in finding that a segregated law school for Negroes could not provide them equal educational opportunities, this court relied in large part on those qualities which are incapable of objective measurements, but which make for greatness in a law school. In McLaren v. Oklahoma State Regents, the court, in requiring that a Negro admitted to a white graduate school be treated like all other students, again resorted to intangible considerations. His ability to study, to engage in discussions and exchange views with other students, and in general, to learn his profession. Such considerations apply with added force to children in grade and high schools. To separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. The effect of this separation on their educational opportunities was well stated by a finding in the Kansas court, or in the Kansas case, by a court which nevertheless felt compelled to rule against the Negro plaintiffs. Quote, segregation of white and colored children in public schools has a detrimental effect upon the colored children. The impact is greater when it has a sanction in the law, for the policy of separating the races is usually interpreted as denoting the inferiority of the Negro group. A sense of inferiority affects the motivation of a child to learn. Segregation with the sanction of law, therefore, has a tendency to retard the educational and mental development of Negro children and to deprive them of some of the benefits they would receive in a racially integrated school system. Whatever may have been and then the footnote is, a similar finding was made in the Delaware case. I conclude from the testimony that in our Delaware society, state-imposed segregation in education itself results in the Negro children as a class receiving educational opportunities which are substantially inferior to those available to white children otherwise similarly situated. Whatever may have been the extent of psychological knowledge at the time of Plessy v. Ferguson, this finding is simply supported by modern authority. And then he's citing to a book. Any language in Plessy v. Ferguson contrary to this finding is rejected. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, we hold that the plaintiffs and others similarly situated for whom the actions have been brought are, by reason of the segregation complained of, deprived of the equal protection of the laws guaranteed by the 14th Amendment. This disposition makes unnecessary any discussion whether such segregation also violates the Due Process Clause of the 14th Amendment. Footnote 12. Okay. Because these are class actions, because of the wide applicability of this decision, and because of the great variety of local conditions, the formulation of decrees in these cases presents problems of considerable complexity. On re-argument, the consideration of appropriate relief was necessarily subordinated to the primary question, the constitutionality of segregation in public education. We have now announced that such segregation is a denial of the equal protections of the law. In order that we may have the full assistance of the parties in formulating decrees, the cases will be restored to the docket, and the parties are requested to present further argument on questions 4 and 5 previously propounded by the court for the re-argument of this term. The Attorney General of the United States is again invited to participate. The Attorneys General of the states requiring or permitting segregation in public education will also be permitted to appear as amici curiae, whatever, upon request. Curiae? I don't remember. To do so by September 15th, 1954, and submission of briefs by October 1st, 1954. I think this is when you're like, amicus brief. This is like when you like are outside people are giving an impartial advisor, often voluntary, to a court of law in a particular case.
Amicus.
Curiae? Is this curiae? So when people like write in to the court to like speak about a particular issue, you like these briefs will be filed by people that aren't necessarily parties to a case. You should recap what you've read every few paragraphs for listeners who don't comprehend. Well, basically, I mean, it's only a 14-page decision. Not even, it's like a 10-page decision. So basically, they're just arguing that, listen, separate but equal, when it was passed, when the 14th Amendment was passed, education wasn't even really a thing in the United States in any kind of standardized way, a consistent way across all the states. As time has gone on and states have now been providing education, if the state of which you are taxed and you are an entity of the state, you're part of the state, if you're going to be part of this, you're going to pay taxes towards it and the state is going to provide something, then the 14th Amendment, which is the amendment that contains not only the insurrection thing, but also is where equal protections under the law, I think, comes from. You're being deprived of your right. You're being deprived of your right under that amendment because schools have been shown that if they're separate but equal, the outcomes are highly disparate, and it doesn't seem like the separate education when provided by the states, is doing what they should be doing, basically, in accordance or in concordance with this constitutional amendment. Just as a quick thing, a reading of the 14th Amendment. Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protections of the laws. Section 2 is representatives shall be appointed or apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed, but when the right to vote at any election for the choice of electors for president, vice president of the United States, representatives in Congress, the executive and judicial officers of a state, and the members of the legislature thereof is denied to any of the male inhabitants of such state, being 21 years of age and citizens of the United States or in any way abridged, except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens. 21 years. Is this? Do we even use this anymore? This is just how you apportion representatives. I'm guessing this has been superseded by some other amendment or some other thing, right? I think Section 3 is basically defunct because the Supreme Court didn't like Daddy Trump getting ejected from state ballots. Section 4 is the validity of the public debt of the United States authorized by law, including debts incurred for the payment of pensions and bounties for services and suppressing insurrection and rebellion shall not be questioned. So I don't know if this established for the ability of the U.S. to have a debt, to issue bonds maybe. I don't know the history behind each of these amendments, and then, or each of these sections. And then Congress shall have power to enforce by appropriate legislation the provisions of this article. So if Congress wants to make laws about any of these particular things, then they can. Ugh. Section 3 mentions the president or does it imply it? Section 3, this is the Section 3 of the 14th Amendment was what the huge Colorado case was about. But this section, this is basically, the Supreme Court basically said they didn't really like how it was being used to bully Trump, so they kind of got rid of it. But Section 3 says that no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof, but Congress may, by a vote of 2/3 of each house, remove such disability. Based. Chapter 2 of John Locke's Second Treatise of Government, about 4 pages that our founding fathers adored and eventually plagiarized. Sacramento State is a good PDF for fellow patriots. Okay, gotcha. The Supreme Court quoted Section 5 to dismiss that. They might have in their rationale. I think they did, but it doesn't really make any sense. And I guess it's kind of funny now that we've actually read the Supreme Court decision. Now you can see illustrated in really plain terms. Actually, fuck. Do I have this? Fuck. What am I looking for? It's research, legal, U.S. Supreme Court. Trump v. Anderson. Was it Trump v. Anderson? Yes, it was. Do they not mention that in here? I thought they did. I thought they referenced that. Oh, yeah, it is. Okay, they don't. Okay. Let me see. So it says right here, this was in the Supreme Court ruling about kicking Trump off the Colorado ballot. The Constitution empowers Congress to prescribe how those determinations should be made. The relevant provision is Section 5, which enables Congress, notice how they say enables, not requires, subject, of course, to judicial review, to pass appropriate legislation to enforce the 14th Amendment. Or, as Senator Howard put it at the time the amendment was framed, Section 5 casts upon Congress the responsibility of seeing to it for the future that all the sections of the amendment are carried out in good faith. Congress's Section 5 power is critical when it comes to Section 3. Indeed, during a debate on enforcement legislation less than a year after ratification, Senator Trumbull noted that notwithstanding Section 3, hundreds of men were holding office and violating its terms. The Constitution, Trumbull noted, provided no means for enforcing the disqualification, necessitating a bill to give effect to the foundational or fundamental law embraced in the Constitution. This is mentioned a few other times, but yeah, they reference the idea that serious questions, blah, blah, blah. Yeah. One of the big arguments that they'd made in that opinion was that this statement here saying the Congress shall have power to enforce by appropriate legislation the provisions of this article. This was one of the arguments that was relied upon by the court in a kind of 9-0 decision that was relied upon to say, oh, well, look, Section 3 doesn't apply because Congress hadn't made laws about it. However, as we just read here in Brown v. Board of Education, the opinions of the separate but equal doctrine as it's applied to schools was changed as a result of how the Supreme Court read the 14th Amendment, especially Section 1 of the 14th Amendment, and it didn't require Congress passing a law for them to read it that way. Because when an amendment passes into law, unless there's language specifying otherwise, stuff that is in the Constitution is considered law, full stop. Okay? Remember that just as a quick construction of government, because sometimes I feel like, and I don't think I'm wrong here, but maybe I am. I got into a little argument with the uncivil law guy about like, oh, the Constitution and federal law, these are different things. He's like, no, it's all federal law. It's federal law. I'm not like formally educated here, so maybe I'll disagree if I read something different in the future. But like law and the Constitution are different things, okay? The Constitution of the United States, okay, is the document which gives power, guidance, authority, everything to the 3 different branches of government, okay? Meaning that the legislature, who's responsible for passing laws and who's responsible for creating statutes, legislation, right? The legislature, right? They get their power to do so from the Constitution. So when the legislature passes a law, to say that it's a law like the Constitution is laws, I don't know in legal terms. I haven't taken a constitutional law class, but I would be surprised if they refer to it in strictly the same manner. The Constitution doesn't just like have a list of laws like the legislature makes laws, because at any point in time, the legislature can be overridden by the Constitution. The legislator cannot make things that contradicts the Constitution ever. And then when the judiciary is interpreting like the legislature, there is no such thing as like a conflict between the legislature and the Constitution that has to be resolved one way or another. Those conflicts are always resolved with adherence to the Constitution every single time. This document is what gives power to all 3 branches of government. The only way to change the Constitution is through the process of constitutional amendment. But a constitutional amendment is not just a new law that's passed. It's a changing of, an amending of the Constitution itself. So once a constitutional amendment is suggested, and through a huge rigorous process of state, both halves of Congress and the president, the president must be in on that, right? Agreeing, I actually don't know if the president is involved in signing off and ratifying an amendment. Then this document is changed, but just because you change the document, you go back to the exact same thing before in terms of how it gives power to all of these particular entities. So if the Constitution says something, then that thing is guiding every other thing. Nothing can be in conflict with the Constitution, or it shouldn't be. So if it says a particular thing here, no person shall be a senator or representative of Congress because of some qualification, then that is the rule, period. Doesn't matter unless if there was language in this, in the Constitution, there's something like, no provision shall have been seen to have taken effect until or unless Congress passes some law to give credence to it or something, or to something, then you could say, okay, but that's not because of something Congress said, it's because something the Constitution has said or the amendment, in the Constitution said it. But that reading of Section 5 that is given by, that was given 9-0 by the court, I think it's a totally bogus reading because, like we just saw for this, for equal protections, Congress didn't have to pass laws to give effect to Section 1 of the 14th Amendment. Congress didn't need to pass a law. As soon as this amendment was added to the Constitution, it's in full force and effect because it's the Constitution of the United States, and there's nothing in here otherwise that would contradict that. But, okay. Okay. Sorry, fuck, we went down a thing. Okay, back to our letter.